Fraud is a constant threat to your notary commission. You need a shield. The book by Derek Spruill, Notary Fraud Shield, could provide you with some advice. Learn real-world tactics, notice red flags, and develop refusal strategies to protect your notary commission. Buy your copy of Notary Fraud Shield by Derek Spruill from any online bookstore, Amazon.com, Barnes & Noble Bookstore, booksofmillion.com, bookshop.org, Mobile Notary by DerekSpruill.com, or download from Kindle to obtain your essential notary book to help with all your notarization starting today.
Imagine sitting across the table from an elderly woman in an assisted living facility.
Oh, that's always a tough environment.
Yeah, exactly. She's frail, she's confined to her bed, and honestly, she looks incredibly confused.
Right.
And clustered tightly around her are like 3 adult children. They're agitated, pacing back and forth, and the room just feels like a pressure cooker.
You can just feel the tension.
You really can. And then one of them just shoves a clipboard into your hands, points at a blank signature line on a living will, and says, look, we're in a massive hurry. Just stamp the paper so we can get this over with.
Oh, I mean, the hair on the back of your neck just stands up, right?
Completely. Every single instinct is telling you something is horribly wrong. But, you are a brand new entry-level notary.
Yeah, and you really want to provide good customer service.
Exactly. You want to be helpful, and you're probably terrified of confrontation. So, do you actually know how to safely and legally walk away from that table?
Welcome to Notary Knowledge. I'm Eddie.
And I'm Marylyn. Whether you're driving to your very first signing appointment, or, maybe you're sitting at your kitchen table staring at that brand new rubber stamp you just unboxed, you are absolutely in the right place today.
Yeah, we totally know that feeling. Holding your commission certificate from the state and suddenly realizing the immense legal gravity of what you just signed up for.
It's a heavy moment. Our mission today is to equip you with the practical, real-world tools you need to protect yourself and, of course, the public.
And to do that, we are drawing directly from the fundamental texts of our profession. We're pulling insights from the 2020 Notary Public Code of Professional Responsibility, alongside, various state-specific commissioning handbooks and statutes.
Right, because these are the governing documents that dictate exactly what we can and absolutely cannot do.
Exactly. And if you recall, in prior episodes, we laid down a lot of the theoretical groundwork.
We did, yeah. We defined the basic notarial certificates. We spent a lot of time on acknowledgments, where you verify someone is signing of their own free will versus jurats.
Right, the jurats, where you administer a formal verbal oath, compelling the signer to swear to the absolute truth of a document's contents.
Yep. So if you haven't heard those discussions, go back and give them a listen, because they really are the building blocks of everything we do. But today, we're taking those definitions out of the textbook.
We are bringing them into the messy, unpredictable real world.
We are launching a very special segment today. It's called Foundational Fridays, Refusing the Act, How to Say No Legally.
Because the reality is the ability to refuse a notarization is like the single most critical skill a new notary can possibly develop.
It is, but saying no just feels so unnatural. I mean, we are wired to be helpful.
Oh, totally. But our goal for you today is to completely reframe what customer service actually means in this profession.
Right. Saying no is not a failure. It is the ultimate fulfillment of your duty as a state-commissioned gatekeeper against fraud.
That's a perfect way to put it.
And hey, before we get into the really heavy details, I want to strongly encourage you to build your foundational knowledge by picking up the Notary Knowledge books by Derek Spruill.
Yes, those are absolute lifesavers.
They really are. When you are standing in a client's living room and some complex situation arises, you need a reliable reference right there. Visit the Notary Knowledge website to get your copies. It is a critical investment in your long-term success.
Having those physical resources at your fingertips just changes the game. It moves you from guessing to actually knowing.
Exactly. So to truly grasp the mechanics of refusing a notarization, we first have to deconstruct this massive misconception.
Right. We have to separate the role of a notary from standard corporate customer service.
And that is the hardest mental hurdle for a novice. I mean, if you work in retail or hospitality or just standard administration, the golden rule is always, the customer is always right.
Yeah, if a customer brings you a problem, your entire job is to bend over backwards, find a loophole, and just make the transaction happen.
Right. Friction is considered bad customer service. But the moment you take your oath of office and become a notary, that entire paradigm is just thrown out the window.
Because you are no longer a corporate representative. You are a ministerial official of the state. You're an active statutory deterrent to fraud.
A deterrent, yeah. The 2020 Notary Public Code of Professional Responsibility was actually drafted specifically to address this tension.
Right. The authors recognize that notaries operate in this highly fragmented system across 50 different states, and, well, we needed a unified ethical compass.
And that code outlines 10 guiding principles. It is completely unambiguous on this point. Refusing an improper request is an ethical imperative.
It's not just a suggestion to be careful. It is a strict mandate to actively stop bad transactions.
But, I look at the financial pressures, especially for a newly commissioned mobile notary who might be trying to build a business.
Oh, the pressure is huge.
It is. You drive 45 minutes in heavy traffic just to get to a signing appointment. The agreed-upon fee is, say, $100.
Right.
You sit down, you open your journal, and you immediately notice a massive red flag. Maybe the ID doesn't match, or the document has entire paragraphs just left totally blank.
Yeah, and the pressure to just push through, apply the stamp, collect the $100, and go home, it is immense.
The temptation is incredibly real. You really don't want to waste the trip, but you have to weigh that $100 fee against the catastrophic legal realities of performing an illegal notarization.
Because the state does not care if you were just trying to be polite. If you perform an improper act, the financial and legal penalties are severe.
We are talking about fines that can range from $1,000 to $10,000 per infraction, depending on your specific jurisdiction.
$10,000. And that is just the administrative penalty. A fine like that is designed to be proportional to the damage a fraudulent document can actually cause.
Yeah, and beyond fines, the state can instantly revoke your commission, which just destroys your business overnight.
And honestly, even more terrifying is the civil liability.
Oh, for sure.
If you improperly notarize a forged real estate deed because you're trying to be helpful and you ignored a bad ID, you can be sued personally by the defrauded homeowner for the entire value of that property.
Which means we are talking hundreds of thousands of dollars in damages.
Exactly.
Plus, if you start telling the client which certificate they need or how to fill out their forms, you cross the line into the unauthorized practice of law.
And that can carry actual criminal prosecution, risking bankruptcy, the loss of your commission, and criminal charges for a $100 travel fee. It's the worst risk-to-reward ratio imaginable.
It really is. I like to frame this internal conflict as the helpful trap.
The helpless trap, yes.
As novices, we are naturally empathetic. We don't want to be the reason a family's loan doesn't fund on a Friday afternoon or, the reason someone's medical directive is delayed.
The human element at the signing table is so powerful. You're looking into the eyes of a stressed, anxious person, and you hold the literal rubber stamp that can solve their immediate problem.
And withholding it feels incredibly harsh.
It really does.
But I always come back to the analogy of a highly trained CPR lifeguard. Let's say you are fully certified in CPR. You know how to assess an airway, perform chest compressions, manage circulation.
Right, you have a specific skill set.
Exactly. So you're walking down the street and someone collapses. You rush over, relying on your specific training to stabilize them.
Mm-hmm.
You are providing a vital life-saving service entirely within the scope of your mandate.
Yes.
But just because you desperately want this person to survive, that does not mean you reach into your pocket, pull out a pocket knife, and attempt open-heart surgery right there on the sidewalk.
I mean, if you attempt that surgery, you are no longer a rescuer. You actually become the immediate cause of catastrophic harm.
Exactly, because you are operating completely outside of your legal jurisdiction and your medical expertise. The absolute best way to protect that person on the sidewalk is to stay rigidly within your lane. Perform the CPR. Wait for the surgeons.
That's a great analogy. For a notary, verifying identity, witnessing the signature, administering the oath, that is your CPR.
Yep.
The moment you start ignoring expired IDs or glossing over blank spaces or offering legal advice just because you feel bad for the client, you are attempting sidewalk surgery.
You are putting the public, the transaction, and your own life in massive jeopardy.
The protection lies entirely in the protocol. Refusing a notarization isn't something you do on a whim. The laws in states like Texas specifically require a notary to deliberate carefully before refusing a request.
Yeah, the refusal cannot be arbitrary or based on personal prejudice.
Exactly. But here is the mechanism that should actually relieve a lot of that customer service guilt. When the foundational statutory conditions of a notarization are not met, the notary has zero discretion.
Zero. You do not possess the legal authority to waive the rules.
So when a client begs you to just bend the rules this one time, you literally cannot. The law removes your agency in that exact moment.
You aren't choosing to be difficult. The state legislature is tying your hands. Understanding that really takes the emotional weight off your shoulders.
It really does.
So let's move from the philosophy of refusal into the logistical bedrock of the job. What are the absolute black and white deal breakers? I think it starts with the most fundamental rule of traditional notarization, the physical presence mandate.
Well, physical presence is the golden rule. For a standard paper notarization, the signer must be physically present before you at the exact moment the notarization takes place.
That means sitting across the table, standing in the same room, sharing the exact same physical space.
There are absolutely no exceptions for convenience. The entire purpose of the notarial act is your objective, first-hand observation of the signer's volition and identity.
And you cannot achieve that over a FaceTime call or a Skype session or just a basic Zoom meeting.
No, you can't.
I hear this constantly from novices. A client will say, my husband is incredibly sick. He's resting in the car in the driveway, but he already signed the document, and I have his driver's license right here. Can you just stamp it?
And the answer must be an unequivocal no. If the signer is in the car, you take your journal and your pen and you walk out to the driveway to perform the notarization at the car window, or they come inside. You must see the whites of their eyes in person.
Now, we do have to acknowledge that remote online notarization, or RON, does exist now.
True, but RON is not just hopping on a standard video call. RON operates under its own massive, highly regulated legal framework.
It requires specialized, state-approved technology platforms. They utilize knowledge-based authentication, credential analysis, recorded video sessions.
Exactly. If you are conducting a traditional paper-based notarization with an ink stamp, physical presence is absolute. Without it, the appointment just does not happen.
Period. Let's assume the person is sitting right in front of you. Physical presence is firmly established. The next major hurdle is identification. You have to verify who this human being is, and that requires a valid government-issued ID. This is where so many appointments fall apart because clients will honestly hand you anything with their name on it.
Oh, they try. But the criteria for acceptable identification are incredibly strict. A valid ID generally must be issued by a state or federal government agency.
Right.
It must contain a photograph of the individual, it must bear their physical signature, and it must include a physical description, like height, weight, eye color.
And that automatically disqualifies so many things people try to use. A student ID from a university, disqualified, it's not government issued.
A credit card with their photo on it, absolutely not.
A birth certificate or a social security card? Nope, neither of those has a photo or a current signature. You are generally looking for a driver's license, a state-issued ID card, a U.S. military ID, a passport, or a permanent resident card.
But finding an ID card is only half the battle. The part that trips up new notaries every single day is navigating what you call the expired ID maze.
A maze. It is awful.
The variance in state laws regarding expired IDs is arguably one of the most complex logistical challenges a notary faces. Because we don't have a single federal notary law, you must know your specific state's commissioning handbook intimately.
It's wild how much these rules diverge. Let's look at the extremes. Let's start with the strict states.
Okay, states like Texas and Arizona. They operate under a strict zero-tolerance policy for expired identification.
Zero tolerance.
In these jurisdictions, the ID must be absolutely current. If you are sitting at the signing table in Dallas and the client hands you a driver's license that expired yesterday at midnight, that document is legally invalid for notarization purposes. You cannot accept it.
That just feels incredibly harsh to the client. I mean, they're the exact same person today that they were yesterday when the ID was valid.
They are, but the state draws a hard mathematical line. However, not all states are that rigid. Some recognize that life gets in the way of DMV renewals.
Right, and that is where the grace period states come in. California and Florida offer significant leeway. In those states, a notary is legally permitted to accept an ID that has expired as long as it was issued within the past 5 years.
And I want to clarify the phrasing there because it confuses people constantly. It does not mean the ID expired within the last 5 years.
Right.
It means the original issue date printed on the front of the card is within the last 5 years.
That is a vital distinction. Then you have a block of states that have adopted the Revised Uniform Law on Notarial Acts, which is commonly referred to as RULONA.
RULONA, yes.
States operating under this framework like Iowa, Montana, North Dakota, Oregon, and West Virginia allow a notary to accept an identification document that has expired within the last 3 years.
So we have zero tolerance, 5-year issue dates, and 3-year expiration dates. And on top of all that, state legislatures sometimes carve out hyper-specific exceptions for vulnerable populations.
They do because they recognize that strict ID laws can inadvertently strip constitutional rights from the elderly, for instance.
Virginia is a perfect example of this. Virginia law contains a specific provision allowing residents of assisted living facilities or nursing homes to use a government ID that has expired within the last 5 years.
That makes sense. The legislature understands that a 90-year-old resident in a memory care facility is not going to drive to the DMV to renew their license.
But they still have a fundamental right to execute a power of attorney or a living will.
Exactly. So as a novice, you are sitting at the table, you check the ID, and based on your specific state's laws, it is completely invalid. It's expired past the grace period. Or you live in a strict state. Do you just pack up and leave instantly? Or are there lifelines you can throw the client to save the appointment?
You never just walk away without exhausting the legal alternatives first. The moment a state-issued ID fails, you immediately pivot to asking for a U.S. passport. Passports are the ultimate fallback. They are typically valid for 10 years, which is double the lifespan of a standard driver's license. Very often, a client whose driver's license lapsed 6 months ago will have a perfectly valid passport sitting in a drawer somewhere.
I always ask that question before I even close my journal. Do you have a passport in the house?
Yeah.
It rescues so many transactions. But what if they don't? What if they haven't traveled in 20 years? Can we rely on other people to vouch for them?
This is where we enter the territory of credible identifying witnesses.
Yeah.
This procedure allows third parties to swear an oath confirming the identity of the signer.
But again, the mechanics of this procedure vary drastically from state to state.
They do, and getting it wrong is a major liability.
Let's look at the extremes here, too. How does Pennsylvania handle credible witnesses compared to, say, Florida?
Pennsylvania has a notoriously stringent credible witness requirement. In Pennsylvania, you can use one credible witness to identify the signer. However, that single witness must personally know the signer, and this is the massive hurdle, that witness must also personally know you, the notary.
Which means unless you live in a tiny rural town where everybody knows the local notary, using a credible witness in Pennsylvania is practically impossible for a mobile notary who drives out to meet strangers.
Exactly. The law is designed to create a closed, trusted loop, but it totally sacrifices practicality.
Right.
Now, contrast that with Florida.
Florida's different.
Florida law takes a much more pragmatic approach by utilizing a two-witness system. In Florida, if the signer lacks ID, they can produce 2 credible witnesses. Those 2 witnesses must present their own valid, unexpired government IDs to the notary.
Okay.
They must both swear a formal oath that they personally know the signer, that the signer is who they claim to be, and that it is unreasonably difficult for the signer to obtain a proper ID. But critically, neither of those witnesses needs to know the notary.
That makes it a viable tool for a mobile notary who is meeting a family for the first time. You just need 2 neighbors or 2 friends who have their own valid IDs to step in and take legal responsibility for identifying the signer.
Yeah.
But let's paint a very specific high-stress scenario that happens all the time in the real estate world. You are hired as a signing agent for a massive loan modification. This family is facing foreclosure. If they don't sign these documents today, the bank is taking their house.
High stakes.
It's extremely high. You are sitting at their dining room table. The title company is texting you for updates. The loan officer is frantic. You ask for the borrower's ID, and you realize it expired 2 years ago.
Oh, no.
And you are in a strict zero-tolerance state like Texas. They don't have a passport. They don't have any neighbors home to act as credible witnesses. The borrower looks at you in tears and says, "Please, you are making me lose my home. What do you do?"
It is an agonizing situation. The emotional pressure is just immense. But the answer is absolute. You stop the appointment, you calmly pack up your supplies, and you respectfully decline to proceed.
I can hear the novice notaries listening right now, screaming at the speakers. The borrower is going to be furious. The loan officer is going to yell at you.
They might. But you have to look past the emotion in the room and examine the mechanical reality of the transaction. If you cave to the pressure and proceed without valid identification, you are committing a dereliction of duty. You are falsifying your notarial journal. But even beyond your own liability, think about what happens to that paperwork. When you ship that loan package back to the title company and the lender, it goes through a massive compliance review.
And the lender is bound by federal law.
Precisely. Under the Patriot Act and strict banking regulations, lenders are federally mandated to positively identify their borrowers to prevent mortgage fraud, money laundering, and terrorism financing.
Wow.
When the lender's compliance department sees that you accepted an ID that expired 2 years ago, they are going to reject the entire loan package.
So by breaking the law to be helpful, you didn't actually save their house at all. You just delayed the inevitable rejection.
And you made it worse, because the loan will bounce back, the funding will be delayed, and the title company will have to send a different notary out to do the signing all over again once the borrower finally secures a valid ID.
That's a nightmare for everyone.
In the meantime, you have just demonstrated to the title company, the lender, and the state that you are willing to compromise the integrity of the Notarial Act under pressure. You will incur extreme liability.
Yeah, you will almost certainly be blacklisted from that title company's approved notary rotation, which ends your business relationship with them.
And you expose yourself to state disciplinary action. The absolute fastest, safest way to keep a real estate transaction moving is to do it exactly by the book the first time, even if it means halting an appointment to demand proper ID.
That is such a powerful reframe. Stopping the appointment is actually the most protective thing you can do for the borrower in the long run.
Absolutely.
Okay, so let's say the ID is pristine. We have positively identified the human being sitting across from us. They're physically present. The next major reason you will have to refuse a notarization shifts from the person to the paper. We must verify the integrity of the document itself.
This is where a notary's systematic attention to detail becomes paramount. Now, it is crucial to state that a notary is not responsible for the underlying legal substance or the fairness of the document.
Right, you aren't evaluating if a contract is a good deal.
No, but you are entirely responsible for conducting a visual, page-by-page review to ensure the document is structurally eligible for notarization. The very first red flag you are scanning for is incompleteness.
Blank spaces.
Yes. A notary must vehemently refuse to notarize any document that contains blank spaces within the body of the text, missing pages, or uninitialed whiteouts.
Let's explore the mechanics of why a blank space is so dangerous. Let's say a client brings me a commercial lease agreement. We get to page 3, and there is a blank line for the monthly rent amount. The client says, oh, don't worry about that. My business partner is going to negotiate that final number and write it in tomorrow. Just notarize my signature today.
If you apply your official state seal to that document while that line is blank, you are actively facilitating massive potential fraud.
It's basically a green light for tampering.
Your stamp provides an aura of legal authenticity to that paper. If you notarize it and the signer leaves, they or someone else can go in after the fact and write in a completely fraudulent number.
They could change a monthly rent from $2,000 to $20,000?
They could change the name of the property grantee on a deed. They could alter the interest rate on a promissory note. Because your stamp is on it, the receiving party will assume the document was complete and verified at the time of signing. You are essentially authenticating a lie.
The vulnerability is massive. So how do we fix it at the table?
The document must be completely filled out before your stamp ever touches it. If the blank space is truly meant to be left blank, perhaps a section doesn't apply to their specific situation, then the signer must explicitly cross a line through the blank space.
Or write not applicable or NA in the blank, right?
Exactly, and initially clocked. Once the document is structurally locked and no new information can be secretly added, then you can proceed.
That makes perfect sense. Lock the document down. But what if the document is completely filled out, no blank spaces, but you get to the very last page and there is no notarial certificate?
Oh, this happens constantly.
There is no acknowledgement wording. There is no jurat. It's just a signature line at the bottom of typed letter. The signer looks at you and says, well, you're the notary. You know what to do. Just stamp it.
This is a trap that ensnares countless new notaries who want to demonstrate their expertise. If a document lacks a pre-printed notarial certificate, the notary absolutely cannot choose the type of notarization for the signer.
Wait, really? Even if I have notarized this exact same specific state form 100 times, and I know for a fact it always gets an acknowledgement.
Even then, choosing the notarial act on behalf of the signer constitutes the unauthorized practice of law.
Ah, UPO.
Yes. You are making a legal determination about what specific statutory procedure that document requires to be legally effective in court. You are not a licensed attorney. You do not have the authority to make that choice.
So we are at an impasse. The document needs a stamp, but it doesn't have the wording, and I can't choose the wording. What are my legal options?
Your role shifts to education. You must explain the different types of notarial acts to the signer in plain language. You can define what an acknowledgement is, verifying identity and free will.
Okay.
You can define what a jurat is, administering an oath to truthfulness. You can even show them sample wording from your handbook. But the signer must be the one to definitively choose which act they require.
And what if they just stare at you and say, I have no idea what the difference is, I just need it notarized?
If they do not know, and they cannot contact the document creator, the receiving agency, or an attorney to find out, you must refuse the notarization.
Oh, wow. Okay.
You cannot proceed until the signer makes a clear, independent choice. It is also worth noting that some states remove this dilemma entirely.
Like which states?
States like Maryland, Mississippi, and New Mexico mandate outright refusal if no certificate is present on the document itself. In those states, the burden is entirely on the document creator to include the proper legal wording.
Okay, let's say the signer says, I understand the difference. I choose an acknowledgement. But the document still doesn't have the wording printed on it, and there's no room to squeeze your stamp at the bottom of the page.
Right, you need a loose certificate.
Yeah, and a novice notary might think, oh, I have a pad of pre-printed loose acknowledgement certificates in my bag. I'll just fill one out, sign it, stamp it, hand it to the client, and tell them to staple it to their document when they get home.
Which is one of the most egregious procedural violations a notary can commit. Really, if a signer chooses a certificate and you must use a loose form, you can never, under any circumstances, hand them a loose, completed certificate to attach later. That certificate must be permanently affixed to the document by you, the notary, during the appointment, before you hand it back.
I always compare handing a signer a loose, unattached certificate to handing a total stranger a blank, signed check drawn on your personal bank account.
That is a brilliant way to picture it.
It is an astronomical fraud risk. If you give someone your signed and stamped official state certificate without securely attaching it to a specific document, they could take it home, throw away the letter you actually witnessed, and staple your state-backed authority to a forged real estate deed.
Or a fake last will and testament, or a fraudulent business contract.
Exactly. They now have your official seal authenticating their crime.
It is terrifying when you realize the implications. Fraudsters are incredibly sophisticated. To prevent this, if you must use a loose certificate, you must securely staple it to the document yourself. And you have to go further to destroy its value to a fraudster who might try to remove the staple later.
How do you do that?
On the original document itself, near the signature line, you must write, "See attached notarial certificate." Then on the loose certificate itself, you must write a precise, detailed description of the document it is attached to.
What kind of details are we talking about here?
You write something like, "This certificate is attached to a 3-page last will and testament dated August 19th, 2026, signed by John Doe."
Okay, that makes sense.
By cross-referencing the certificate to the specific document, you bind them together. If a fraudster removes that staple and tries to attach your certificate to a deed of trust, the receiving county clerk will look at your handwriting, see that it describes a 3-page will, and instantly flag the document as fraudulent.
It takes 30 seconds to write that description, and it can literally save your career and protect the public from massive financial loss.
Absolutely.
Let's talk about the specific details on the certificate itself, specifically dates and venues, because these are also massive deal breakers.
Venue is the section at the top of the certificate that usually says state of and county of. The venue establishes the legal jurisdiction for the notarial act. It lists the exact physical location where you and the signer were standing when the notarization took place. If there is a lawsuit 5 years from now regarding this document, the court needs to know exactly which county's laws and jurisdiction governed that signing ceremony.
And if the venue is left blank, or if it incorrectly lists the county where the document was drafted instead of where it was signed, the entire document can be thrown out of court on a procedural technicality.
Exactly. And regarding dates, the rule is incredibly simple but constantly challenged by clients. The date on your notarial certificate must be the exact, true, present date that the signer physically appeared before you.
The true date is non-negotiable. People ask notaries to backdate things all the time.
All the time.
A contractor might say, look, this construction waiver was supposed to be signed yesterday to meet a deadline. I didn't get around to it. Can you just write yesterday's date on your certificate? It's only a 24-hour difference.
You must unequivocally refuse. Falsifying dates, whether you are backdating to the past or postdating for the future, is a criminal offense.
A criminal offense.
Yes. You are an officer of the state and you are intentionally falsifying a public record. The timeline of legal events, especially in real estate and contract law, relies entirely on the absolute truth of that date. If a client asks you to change the date, the answer is an immediate, non-negotiable no.
Okay, so verifying IDs, checking for blank spaces, making sure the date is accurate, all of this is highly objective work. It's black and white. It's checking boxes.
Yes.
But the absolute hardest part for a novice notary and the most anxiety-inducing reason for refusal is the subjective assessment of the human being sitting across from you.
The human element. It is messy, it is deeply nuanced, and it requires a high degree of emotional intelligence and professional vigilance.
It really does.
When we assess the human element, we are looking at two distinct factors, the signer's awareness and the signer's volition. We're also navigating the complex logistical trap of language barriers. Let's start with awareness.
You never really know what physical or mental state your signer will be in until you arrive. You might be dealing with an elderly signer who is suffering from early-stage Alzheimer's or dementia.
Right.
You might be called to a hospital room to notarize a power of attorney for a patient who is heavily medicated on painkillers following a surgery. Or you might walk into a living room and realize the signer is clearly intoxicated.
The notary must assess the signer's basic capacity to understand what is happening in the room. A client cannot execute a legally binding document if they do not possess the mental awareness to understand the consequences of their actions.
The law protects vulnerable people from signing away their rights when they are not in their right mind.
Exactly. Some states have codified this directly into their statutes. Florida, for instance, strictly prohibits a notary from performing a notarization if the signer appears mentally incapable of understanding the nature and effect of the document at the time of notarization.
And beyond basic awareness, there is the issue of willingness. Is this person acting of their own free will, or are they being forced?
Coercion is a subtle and incredibly insidious threat. It doesn't always look like a movie where someone is holding a weapon.
Right.
You must constantly look for behavioral warning signs. Is the signer severely withdrawn, fearful, or avoiding eye contact? Is there an intimidating relative hovering closely over them, physically dominating the space?
Or is a caregiver answering all of your questions on behalf of the signer before the signer can even open their mouth?
Yes. If someone is being pressured, bullied, financially threatened, or emotionally manipulated into signing a document, you are witnessing elder abuse or fraud happening in real time. If you suspect coercion, you must refuse the act.
Another massive trap within the human element is the language barrier. You live in a diverse metropolitan city, you get called out to an appointment, and you arrive only to realize the signer does not speak English, and you do not speak their native language.
This is a critical failure point for many new notaries who just want to be accommodating. If the notary and the signer do not speak the same language, direct, unassisted communication is impossible.
You can't verify anything.
Right. You cannot properly verify their identity by asking questions. You cannot confirm their voluntary intent, and you certainly cannot administer a verbal oath for a jurat if they cannot understand the words you are saying. Therefore, in the vast majority of cases across the country, you must refuse the notarization.
But inevitably, the family is going to offer a solution. They will say, oh, don't worry, the signer's bilingual nephew is right here. He speaks perfect English. He can translate everything for you.
And you must decline that offer immediately. Using a bilingual family member, a friend, or even a professional third-party interpreter during the notarial ceremony is highly prohibited in most states.
Why is that? I mean, from a customer service perspective, it seems like a highly practical solution to get the job done.
Because you, the notary, have absolutely no way to verify if the translation is accurate and impartial. Think about the vulnerability you're exposing the signer to.
Okay, I'm listening.
Let's say you are executing a deed transferring property. You ask the nephew to translate the oath. Do you swear the contents of this document are true? And do you understand you are signing away your house? The nephew might turn to his elderly uncle and say, in their native language, sign this medical paper so we can get your prescription refilled.
Oh, wow.
Or sign this tax form to get your refund. the uncle nods and signs. You would have no idea that massive financial fraud just occurred right in front of your face. The risk of the interpreter manipulating the transaction for personal gain is simply too great.
That is terrifying. Now, there are a couple of specific state exceptions to this rule, correct?
Yes, which is why you must always consult your state statutes. Arizona, uniquely, expressly permits the use of a physically present interpreter during the notarization, provided the interpreter can provide proper identification. Florida has a very nuanced rule. If the signer does not speak English, Florida law requires that the nature and effect of the document must be translated into a language they understand prior to the notarization. However, when it comes time to actually perform the notarial ceremony verifying identity and taking the oath, the notary still needs to be able to communicate directly with the signer.
So ultimately, the universal best practice for risk mitigation, regardless of your state, is to refuse the appointment and refer the client to a notary who speaks their language natively.
Absolutely.
Okay, I have a major pushback here regarding the awareness and willingness assessment. If I am a brand new notary sitting in a hospital room, I am panicking right now. How on earth am I supposed to accurately assess complex medical conditions like dementia or accurately detect subtle psychological coercion without being a licensed doctor or a trained psychiatrist?
That is a very valid concern.
I don't have a medical degree. I am just there to stamp a piece of paper.
And it's a fear every novice has. But it's important to clarify the boundary of your responsibility. Notaries are not diagnosing medical conditions. You are not conducting a clinical psychiatric evaluation.
Okay, then what am I doing?
You are conducting a limited, non-invasive assessment of basic practical awareness. It is about establishing a conversational baseline.
How do you do that practically, especially if they have family hovering around them, creating noise and pressure?
First, if you suspect coercion or notice that the signer seems confused, you must politely but firmly clear the room. Ask the hovering relatives, the nurses, or the caregivers to wait in the hallway so you can speak to the signer privately.
That drops the pressure immediately.
Exactly. Once you are alone, the pressure drops. Then you ask open-ended questions that require more than a simple yes or no nod. Ask them about the weather. Ask them what they had for breakfast or what city they are currently in. This establishes if they're basically oriented to reality.
And once you establish that baseline, you pivot to the document itself.
Exactly. You hold up the document and ask the signer, can you explain to me in your own words what this document is and what it does?
Right.
If they can articulate, this is a power of attorney so my daughter can pay my bills while I'm in the hospital, you have successfully established basic awareness and intent. You can proceed.
But what if they can't?
If they cannot explain it, if they look deeply confused, or if they constantly look to the doorway waiting for a relative to come back in and give them the answer, you do not have the necessary confirmation.
So you have to stop.
At that point, you are not diagnosing dementia. You are simply stating that you, the notary, cannot verify their awareness, and therefore, for their own legal protection, you must refuse the notarization.
That is incredibly practical advice. Just establish a baseline of reality and ask them to explain the document. Okay, so we've covered the why and the when of refusing a notarization. Now we have to talk about the tactical how.
The de-escalation phase.
Yes. How do we actually look a stressed, angry, or desperate client in the eye and say no without causing a massive scene, or worse, putting ourselves in physical danger? We need to talk about tactical de-escalation.
De-escalation is a vital survival skill in this industry. When you refuse a service, people often feel inconvenienced, they feel judged, or they might even feel discriminated against. Their adrenaline spikes.
Naturally.
Your primary goal is to neutralize the emotion in the room and handle the refusal with absolute detached professionalism.
The best tactic I've found, and this is a psychological script you should absolutely memorize, is to always blame the law. Never make it personal. Never say, I'm not comfortable with this, or I don't want to do this. If you use I statements, the client hears a personal rejection. It becomes a negotiation.
Precisely. You must externalize the authority. You remove your personal discretion from the equation completely. Frame the refusal around the statutory requirements that govern your commission.
So you stand on the same side of the table as the client, pointing at the rulebook.
Exactly. You say, state law prohibits me from notarizing a document with blank spaces. Or, my state guidelines strictly require a current, government-issued photo ID, and I am legally unable to proceed without one.
That positions you not as an arbitrary gatekeeper trying to ruin their day, but as a public servant whose hands are tied by the state legislature.
And once you deliver that script, you have to follow the golden rule of de-escalation. Do not debate.
Do not debate.
Difficult clients will immediately try to negotiate. The "I'm in a huge rush" client will demand you hurry up and ignore the rules. The "just notarize it" client will dismiss the missing pages and demand your stamp.
They will try every angle.
You must not argue the nuances of the law with them. You are not there to convince them. You are there to state your boundary. State the rule calmly, pack up your supplies, and leave gracefully. You simply say, "I'm sorry I couldn't help you today. Please contact an attorney or the document creator if you need further guidance." And you walk toward the door.
But what about the physical confrontation? What about the grab and stamp client? This is something people don't talk about enough in training courses.
Oh, it's a very real threat.
You are sitting at the dining room table, you tell them you can't proceed because the ID is bad, and they reach across the table, try to grab your physical rubber stamp out of your hand, and attempt to stamp the paper themselves.
That is an immediate, severe safety and fraud concern. Your stamp is the physical manifestation of your state authority. Never, under any circumstances, let your stamp out of your physical control.
Never.
Do not leave it sitting on the table while you go to the bathroom. Keep it secured in your bag or your pocket until the exact moment you are ready to apply it to the paper. If a client attempts to grab your stamp, the appointment is over instantly.
You don't try to reason with them then?
No. You secure your equipment, you do not engage in a physical tug of war, and you leave the premises immediately.
And once you are safely in your car, your job still isn't done. You must journal the refusal.
Journaling a refusal is arguably more important than journaling a completed successful act.
Why is that?
Because this is the interaction most likely to result in a complaint to the Secretary of State or a civil lawsuit. The client is angry, and they might try to claim you refused them based on discrimination. You must document the exact, objective reasons for the refusal in your journal to protect yourself.
Right, you can't write, "The guy gave me a weird vibe and looks suspicious." That is subjective, and it will not hold up in court.
You must be entirely objective and factual. You write, "Refused notarization of power of attorney because the ID presented was expired by 7 years, and the signer could not produce any legally acceptable alternate identification."
Or something like, "Refused transaction because the elderly signer could not answer basic orientation questions, could not state the purpose of the document, and appeared heavily medicated."
Yes. Those are objective, legally defensible facts that a judge can look at and understand exactly why you halted the transaction.
Now, this brings up a really fascinating and somewhat controversial industry debate regarding what we call the physical safety exception. What happens if you are in a situation where you feel your life is in imminent physical danger if you refuse to apply your stamp? Say a weapon is drawn, or the client physically blocks the doorway.
It's a terrifying scenario, and it is a debate that has raged within the profession for years. There are two distinct opposing schools of thought on how a notary should handle this.
Okay, what's the first one?
The National Notary Association has historically suggested that if a notary feels physically threatened or believes that refusing the notarization would place them in imminent physical danger, they should go ahead and complete the notarization to survive the encounter.
So just do it to survive?
The logic is that you apply the stamp, escape the house to safety, and then immediately call the police to report the coerced act.
The logic there is completely understandable from a human survival standpoint. Your life is worth vastly more than the integrity of a piece of paper. But there is major, intense pushback against that policy from legal experts and seasoned fraud investigators.
Yes, many legal experts argue that this is actually a deeply flawed and highly dangerous policy. Their argument is twofold.
What's the first part?
First, from a psychological standpoint, completing a notarization under threat rarely de-escalates a violent, desperate criminal. It simply means you have now actively aided in the commission of a felony fraud. You haven't diffused the situation, you've just given them what they want.
And the second part of their argument is the damage the document causes.
Exactly. Applying your stamp gives the criminal a seemingly valid, state-sanctioned, weaponized document.
Wow, weaponized.
If you stamp a fraudulent deed of trust at gunpoint, and then you leave, that criminal isn't going to wait around. They're going to immediately take that stamped document, record it at the county clerk's office, steal the property, empty bank accounts, or commit massive identity theft long before the police can intervene and untangle the mess. You have unleashed a legally binding lie into the public record.
So what do these legal experts recommend instead of complying? How do you survive the room without stamping the paper?
They advocate for tactical retreat rather than compliance. If you feel physically threatened, do not argue with the client. Do not formally announce your refusal, and definitely do not apply your stamp.
What do you do instead?
Instead, use a plausible, non-confrontational excuse to leave the immediate area. Say something like, "Oh no, I just realized I left a required state compliance form in my car. I'll be right back."
Oh, that's smart.
Or, "I need to make a quick phone call to my agency to verify an authorization code for this specific document." Use that excuse to physically separate yourself from the threat. Retreat to your vehicle, lock the doors, drive away, and call 911.
It's a heavy, intense topic, but it highlights exactly why this profession requires sharp instincts, situational awareness, and an unwavering commitment to procedure. You are dealing with high-stakes legal documents, large sums of money, and sometimes people act desperately.
Preparation and strict adherence to protocol are your absolute best defenses against liability and danger.
Speaking of preparation and protocol, if you want to keep your records impeccably organized and legally defensible, especially when journaling these complex refusals, you need to upgrade your toolkit. I want to highly recommend the One Ledger Notary e-journal, available right now on the Apple App Store.
Oh, absolutely.
It was crafted by the incredible Magnificent Works team, and it brings your journaling process entirely into the modern era with secure digital precision. It forces you to capture all the right data points, which is exactly what you need if your journal is ever subpoenaed.
It's a fantastic software.
It really is. And because you are a listener of Notary Knowledge, you can use the promo code NOTARYKNOW50. That's NOTARYKNOW50 to get 50% off your first year's annual plan. It is an absolute game changer for your workflow. Also, make sure you check out our amazing video podcast, No Notary, with Eddie Montes Travis, and don't miss Marylyn's 90 Seconds of Notary for quick, hard-hitting tips you can use in the field.
Excellent tools for any professional looking to solidify their practice.
Okay, we have covered a massive amount of foundational knowledge today. We've talked about the mandate, the deal breakers, the human element, and de-escalation. Now is time to put that theory into practice with our special interactive segment. Good question. What would you do?
This is where we see how these abstract rules apply to the messy reality of the job.
We're going to take the rules we just learned and apply them to two specific real-world case studies today. Let's start with scenario one. We're going to call this one David in Ohio.
Let's hear what David is dealing with in his office.
David is sitting in his busy office and a desperate client comes in. The client needs a highly time-sensitive real estate deed notarized today in order to close on a house. If he doesn't sign today, the deal falls through.
Okay, high pressure.
The problem: the client was in a severe car accident a few days ago. His dominant arm is wrapped in a heavy plaster cast, and he physically cannot hold a pen to sign his name on the document. Now, David goes through his checklist, he checks everything else. The client has a valid, unexpired government ID.
Good.
David asks questions, and the client is completely lucid, understands the real estate document perfectly, and clearly possesses free will. But he lacks the physical, mechanical ability to sign his name. So based on the strict rules of refusing an incomplete document, does David have to refuse this notarization simply because the client can't produce a signature? What would you do?
This is a fantastic nuanced scenario because it tests the boundary between a physical limitation and a legal disqualification. If you are David in Ohio, you absolutely do not refuse this notarization.
But wait, how do you notarize a signature that doesn't exist? The paper is technically blank where the signature should be.
You utilize a specific legally recognized accommodation procedure known as signature by mark. The law anticipates that physical disabilities, injuries, or even illiteracy should not strip a citizen of their fundamental right to execute legal documents.
Okay, how does that work?
Under the signature by mark protocol, the client doesn't have to write their full cursive name. They simply make a mark, most commonly an X, but it could literally be any intentional scrawl or line on the signature line.
But if I'm a fraud investigator looking at that document later, wouldn't an X be incredibly easy to forge? Anyone can draw an X. How does that procedure actually prevent fraud?
That vulnerability is exactly why the procedure has built-in stringent safeguards that David must follow. To execute a signature by mark legally, the client's action of making the X must be witnessed by two impartial individuals who have no vested financial or personal interest in the transaction.
Ah, impartial witnesses.
Yes. Those two witnesses stand there, observe the client making the mark on the paper, and the witnesses sign their own names near the mark to attest that they physically saw that specific individual apply it. Then David, the notary, performs the notarial act, often noting in the certificate itself or extensively in his journal that the signature was executed by mark in the presence of those specific witnesses.
Wow, that is clever.
It provides a legally verifiable, fraud-resistant pathway for physically impaired signers. David saves the closing, legally and safely.
It perfectly balances accessibility with security. It's a brilliant procedural safeguard. Let's move on to scenario 2. We're heading down south. Let's call this one Jessica in Florida.
Florida has some very specific statutory rules regarding capacity, so Jessica needs to be sharply focused on her assessment skills.
Jessica is a mobile notary. She gets called out to an assisted living facility to notarize a living will and a power of attorney for an elderly woman. When Jessica walks into the small hospital room, the situation is incredibly tense.
That's like our opening scenario.
Exactly. The elderly woman is lying in bed looking frail. Her family, 3 adult children, are hovering tightly around the bed. The room is loud. A TV is blaring in the background. The family is visibly agitated, pacing back and forth. One of them practically shoves the clipboard at Jessica, pointing to the bottom line and says, "Look, we don't have all day. Just stamp the paper so we can get this over with." What is Jessica's immediate responsibility, and what would you do?
Jessica's walking into a literal minefield of red flags. Her immediate responsibility is not to appease the impatient family. Her ultimate statutory duty is to protect the vulnerable signer lying in that bed.
Right.
Jessica's facing a textbook scenario involving potential coercion and highly questionable mental capacity. She must actively assess the elderly woman's awareness and free will.
But how does she actually do that with 3 angry, loud people shouting in a tiny room? It's an intimidating environment.
She cannot do it accurately with them in the room. The pressure is too high, and the family will likely try to answer for the woman. The very first thing Jessica must do, and this requires immense professional courage and adherence to her de-escalation training, is politely but firmly clear the room.
Right, getting them out.
She must inform the family, using the blame the law script, that Florida state law requires her to speak with the signer privately to complete the identification process. She has to get the hovering, pressuring family members out into the hallway and close the door.
Okay, so let's say she manages to get them out. The door is closed. The room is quiet. It's just Jessica and the elderly woman. Now, what is the specific protocol?
Now, Jessica conducts her non-invasive assessment. She asks those baseline orienting questions to cut through any confusion. "Hello, ma'am. How are you feeling today? Can you tell me what day of the week it is? Do you know what city we are in?" She gauges the woman's responsiveness and clarity. Then she pivots directly to the living will and the power of attorney. "Can you tell me what these documents are for? Are you giving your children control over your medical decisions today?"
And what if the woman just stares blankly or says she doesn't know what the paper is or seems highly confused about why Jessica's even standing in her room?
If the woman lacks basic awareness or is highly confused by the questions, Florida law specifically dictates that the notary must not proceed. Jessica must immediately refuse the notarization.
She has to stop right there.
Yes, she is fulfilling her role as a gatekeeper, protecting that vulnerable signer from what appears to be aggressive familial coercion. Jessica must then pack up her journal and stamp, exit the room, inform the family in the hallway that she cannot legally proceed because the statutory requirements for awareness were not met, and leave the facility without debating them.
And document it.
Critically, yes. She must document the entire interaction objectively in her journal, noting the family's aggressive behavior, the clearing of the room, and the signer's inability to answer basic questions regarding the document.
It's a tough, emotionally draining situation, but following those steps to the letter is exactly what separates a professional state-commissioned gatekeeper from someone who just mindlessly stamps paper. Those scenarios really highlight how quickly things get complicated in the real world. You always have to be thinking 3 or 4 steps ahead, anticipating fraud, coercion, and your own liability.
You absolutely do. The job requires constant vigilance. And as we wrap up this foundational knowledge on refusing the act, I want to leave you with a final provocative thought to ponder as you continue to build your career.
Okay, what is it?
Everything we have discussed today, checking physical ID cards, assessing a hovering relative, clearing a crowded hospital room, looking a signer in the eye, is based on the traditional physical reality of being in the same room. But as we rapidly approach the 2026 vision of fully digital, paperless workflows and remote online notarizations, the landscape of refusal is going to shift dramatically.
Because you aren't in the room with them anymore, you are looking at them through a webcam lens. Your field of vision is entirely restricted to what the camera shows you.
Precisely. How will the subtle human cues of coercion change? If an intimidating relative is standing just 3 feet off camera, silently threatening the signer with a glare or a raised hand, how will a remote notary accurately assess willingness?
That's a great question.
How do you gauge the overall awareness of an elderly signer when you can only see their face on a screen and you cannot observe their body language, their nervous hands, or the overall environment around them? The digital age is not going to eliminate the need for the notary as a gatekeeper. It is simply going to require far sharper instincts and entirely new, sophisticated protocols for determining when to say no.
That is a fascinating and somewhat daunting challenge for the future of our industry. We are going to have to adapt and evolve our assessment skills for the digital screen. Well, that is all the time we have for today's foundational segment. We hope this empowers you to step into your role with absolute, unshakable confidence, knowing that your power to refuse is your greatest tool for protecting the public.
Remember, every time you say no to an improper request, you are elevating the integrity of the entire notarial profession.
If you have questions about a specific scenario you've encountered in the field, or if you just want to learn more, we want to hear from you. Email your questions to Derek@DerekSproul.com. We will try to answer as soon as possible at the end of our shows. We love unpacking real-world challenges from our listeners. Before we go, we have some mandatory credits to read. Credits: exec producer Derek Sproul, lead writer Marylyn Trotter, graphics Eddie Montes Travis, music Thomas Bynum, produced by Magnificent Works Business Solutions. Don't just be listeners of the knowledge, be doers of the knowledge. This is notary knowledge. Until next time.
Fraud is a constant threat to your notary commission. You need a shield. The book by Derek Sproul, Notary Fraud Shield, could provide you with some advice. Learn real-world tactics, notice red flags, and develop refusal strategies to protect your notary commission. Buy your copy of Notary Fraud Shield by Derek Sproul from any online bookstore, Amazon.com, Barnes & Noble Bookstore, booksofmillion.com, bookshop.org, Mobile Notary by DerekSproul.com, or download from Kindle to obtain your essential notary book to help with all your notarization starting today.